the appeal of Michael Paul Chen-Young and others against Eagle Merchant Bank Jamaica Limited.
Yes, Mr. Braham.
May it please you, my lord and my lady.
Just before you start, can we just check that both Mr. Hilton and Mr. McCoy can hear, and that we can hear them?
May it please you, my lord and lady. I can hear you very well.
Good, thank you.
So can I, my lord. Good morning.
Thank you very much. And may I also say that we propose to take a short break during the course of the proceedings, because 3 hours is quite a long time, especially if you're staring at a screen, as two of you are. And we will do that during the time allocated to Mr. Hilton, of about 10 minutes at a convenient moment at that stage in the proceedings.
Very well.
Yes, Mr. Brown.
My lord, the three questions certified by the Court of Appeal they are to be found at page 347 of your electronic bundle, which is part of the judgment of Mrs. Justice MacDonald Bishop, my lord.
347?
Yes. My lord, we will, of course, be submitting that the three questions ought to be answered in the affirmative. In relation to the first question, my lord, we submit that on a proper interpretation of Section 19 of the Constitution, which is the charter within the Charter of Rights, my lord, the Court of Appeal has the jurisdiction to hear and determine an issue raised with respect to any rights secured by the Charter. And so, my lord, and this, of course, is with respect to an issue raised for the first time before the Court of Appeal, and in particular, dealing with the conduct of the Court of Appeal itself. In order, my lord, to lay the foundation for that, I would quickly point to you the relevant sections of the Constitution that I think will assist your lordships in coming to a determination. And my lord, section 13.2, my lord, the Charter of Rights is separate. What happened is that when the Constitution was first promulgated, it had a section called Fundamental Rights and Freedom. That was subsequently replaced by the Charter of Rights. And so that's why the Charter of Rights is separately set out in the electronic bundle, which I will bring to your attention. And, my lord, I would say that section 13.2 is a good starting point, my lord. And that section, my lord, if I may quickly summarize what it says.
Can you give us the electronic page reference, please?
That is to be found, my lord, at page 1133.
Thank you.
So that section 13.2 says that subject to section 18 and 49 and to subsections 9 and 12 of this section, and save only as may be demonstrably justified in a free and democratic society, A, this charter guarantees the rights, freedoms set out in this subsection, and in subsection 3 and 6, of this section, and in section 14, 15, 16, and 17. And B, Parliament shall pass no law, and no organ of the state shall take any action which abrogate, abridge, or infringe those rights, my lord. And then, my lord, section 13.3R of the Charter says, and that, my lord, is at 1135 to 1136. The rights and freedoms referred to in subsections 2 are as follows, and in R says, the right to due process, as provided in section 16, my lord, and that is at page, as I said, 1135 to 1136. Section 16.2, my lord, says that in the determination of a person's civil right and obligation or of any legal proceedings which may result in a decision adverse to his interests, he shall be entitled to a fair hearing within a reasonable time by an independent and impartial court or authority established by law. And that's page 1144. Now, my lord, we submit that section 16.2 has 4 or 5 elements. There must be in question civil rights and or obligation or legal proceedings, and that, of course, may result adverse to the interests of the my lord. 2, there is, my lord, there should be a fair hearing within a reasonable time, and, my lord, by an independent and impartial court or authority, and C, established by law. And I point this out, my lord, because you will come later on to see that the Court of Appeal declared that the judges, when they delivered their judgments, were not judges. Therefore, I respectfully submit, my lord, that they would not, at the time, have been a court established by law. My lord, for completeness, may I refer you to section 106? That, my lord, is set out at page 718 to 721. And if I may summarize, section 106.1, the judge holds office until the age of 70.
I'm so sorry, I missed your page number.
It is, my lord, at 718 to 721. 718 to 721.
Oh, I see.
721.
Yeah, thank you.
Section 6, subsection 1, my lord, declares that a judge of the Court of Appeal holds office until the age of 70. Subsection 2, that the judge may, of course, continue in office with the permission of the Governor General to enable him to deliver judgment and complete matters that he has at hand. Subsection 3, my lord, nothing done by a judge of the Court of Appeal shall be invalid by reason only that he has attained the age at which he is required by this section to vacate his office. And that section was the subject of detailed conversation about the officer, my lord, de facto officer.
We've read the Court of Appeal's
Very well, my lord.
lengthy and learned judgments on that question, and we don't understand that question is subject to this appeal.
No, my lord. It's not at all.
No, but we thought nonetheless we should read what the Court of Appeal had to say about it.
It would be useful. Nevertheless, my lord, I move on to say that, my lord, we submit that where a charter right, such as sub 16.2, is being or is likely to be contravened in relation to any person, and that's my summary of it, my lord, then without prejudice to any other action with respect to the same matter which is lawfully available, that person may apply to the Supreme Court. And my lord, that section of section 19, my lord, I believe, subsection 1. And
page number, please.
Is it 1149? Yeah. I believe it is 1149, my lord.
Thank you.
Am I correct?
Yes.
Yes. 11, that section, my lord, and that proviso are the words that says without prejudice, etc. we submit is important because that demonstrates that the Supreme Court does not have exclusive jurisdiction. And my lord, you will see that we relied on two Privy Council cases, Bowie and against the Queen, and that, my lord, is found at page 837 to 839, paragraphs 6, 7, 10, and 11. And equally, my lord, the case of Silly Creek Estate and Marina Company Limited against the Attorney General of Turks and Caicos Island, and I believe it starts at paragraph, I'm referring to paragraphs 65 to 68, particularly 68 at page 942 to 943. And of course, my lord, that is developed in the statement of case. I don't think I need to, I won't say anything further on that, my lord. We feel and we submit that that in itself is sufficient to give the court jurisdiction. Then, my lord, we submit similarly, further, that when you look at the Court of Appeal rules, section 215, which is at page 1176, you'll see that the Court of Appeal has all the powers and duties of the Supreme Court. And we feel and submit that of course, would confirm the jurisdiction of the Court of Appeal. Then, of course...
That doesn't mean that you can just bring a claim in the Court of Appeal that you could bring in the Supreme Court.
No, my lord.
Because it has all the powers.
That is quite so. But what it means, my lord, that a matter that is before the Court of Appeal, my lord, it would have all the powers of the Court of Appeal of the Supreme Court with respect to that matter.
Certainly, but that's where there's a difference, isn't there, between whether what you're claiming is costs in the particular matter before the court, or whether you're making a new claim for damages for breach of a constitutional right.
My lord, once the Court of Appeal assumed jurisdiction in the matter, my lord, whether it is an appeal on a substantive matter, or as in this case, by a notice of motion, and you'll see that the Court of Appeal declared itself to have jurisdiction to hear the matter. Some of the judges relied straight on the inherent jurisdiction, others relied on inherent jurisdiction and other parts of the law and rules. But once they declared themselves seized of the jurisdiction, then all the powers related that the Supreme Court would have would then equally apply in that situation, my lord, and that would be my submission.
But they certainly had jurisdiction over the appeal between Mr. Chen-Young and the bank, but those weren't proceedings to which the state was a party before they got to the Court of Appeal. Isn't that an important difference between the Bowie case and the Silly Creek case, which were both actions started against the Crown in various guises, in which then it was appropriate, in one case, in the Silly Creek case, it had actually been pleaded, the constitutional claim in the pleadings, whereas in this case, presumably there was no pleading in the original action about this constitutional matter, and the state wasn't even a party before it got to the Court of Appeal.
That is so, my lord, but we say that once we accept that the rules permit the Court of Appeal to award costs against a person who was not a party to the claim, a third party, because the Supreme Court rules and the Court of Appeal rules permit the court to do so.
Now, the third party cost point is a different point. We're dealing here with the breach of constitutional rights.
Yes.
Which is seeking, as I understood it, compensation from the government
Yes.
for the conduct of the judges, broadly.
That's right.
But do you say that in an appeal you can add any party to the proceedings?
You cannot
whether
add
it's the state or some other person?
waiver indulgence, yes. The way I would respond to that, my lady, is to say that while the Attorney General was not a party to the substantive appeal, when we came to the issue of the challenge of the conduct of the judges, so to speak, that was an issue to which the Attorney General was properly to be associated, my lady. Because, of course, in Jamaica, there's a practice, if there's a constitutional issue, that the Attorney General is joined to that constitutional issue, my lady. So he is properly joined in the circumstances of this case, where it was a constitutional issue that was to be determined by the court, not the substantive arrangements that was in the substantive appeal, but the constitutional issue as to the conduct of the court.
So we could test it by saying, suppose that part of the compensation claimed was not for costs, but was for, let's say, the mental distress of having to wait with your bank account frozen for indefinite period of time, or something like that, non-pecuniary loss.
Well, the question...
could that have been, could that be awarded by the Court of Appeal?
Technically, yes, but the question would be whether it would be appropriate in that circumstance for the court to assume jurisdiction, bearing in mind that that is a far more complicated issue that would require evidence and other interrogation that may not be appropriate for the Court of Appeal. So the Court of Appeal would have jurisdiction.
Under what provision?
They would have jurisdiction pursuant to Section 19(1).
But that doesn't affirmatively give jurisdiction to deal with the case. It just says that that the jurisdiction of the Supreme Court is not exclusive, so that if there is some other procedure lawfully available, then the other court can decide the constitutional question. So what is the procedure under which the Court of Appeal could have considered whether to award non-pecuniary damages, or whether that's too complicated and they ought to leave it, ought not to do
it
so?
Would, my lord, my response would be that if it arose during the course of the appeal, my lord, the court would properly have jurisdiction, but it may not be appropriate in that case.
So you're saying it's ancillary, this question, to the appeal on to the question of the nullity of the proceedings?
That is what I would say, my lord, as an appropriate summary of the position.
Just going back to Rule 2.15 on page 1176, you seem to be equating powers with jurisdiction. But I'm wondering whether that's right. If one looks at the first part of 2.15, in relation to a civil appeal, the court has the powers set out in Rule 1.7, and those are general case management powers. In addition, all the powers and duties of the Supreme Court, and then power to affirm a judgment, give any judgment, those all look to remit, to order a new trial, make an order as to costs, etc. Those seem to be powers which are something different from the jurisdiction to hear a case. They're dealing with what the court can do over a matter which it has jurisdiction to determine, rather than actually founding jurisdiction to determine. Is that?
Lady, what I would say that could be an interpretation of the section. But I don't only rely on that, my lady. I do rely on the Section 19(1) itself, and I also rely on the fact that the Court of Appeal said that it had inherent jurisdiction to entertain the matter.
As I understand it, you say the Court of Appeal had jurisdiction to deal with the nullity application.
Yes, sir.
So they're dealing with that. And then it could be regarded, for example, as an incidental decision under G of this of its powers to deal with the consequential question of compensation under the Constitution.
It would be ancillary to that, my lord, and the Court of Appeal, as a part of determining the nullity, would be entitled to say what happened to the costs of the matter. Awarding costs one way or the other is not unusual to the court, my lord.
Costs isn't, but I was pursuing the question of damages rather than costs of the proceedings. And you,
But we are asking,
you saying they can award damages.
by way of cost, in this case, by way of cost. And I'm saying so, my lord.
So
Can I just ask you about the point you made about inherent jurisdiction? Are you saying that irrespective of the rules of court, in any event, the Court of Appeal would have an inherent jurisdiction to do everything that the Supreme Court would be able to do?
If there is a rule that expresses a position, then I would respectfully say that you would not be able to have an inherent power or jurisdiction which is actually contrary to the rule. I would say that the inherent jurisdiction has to deal with a situation that would not be otherwise covered by express law or rule. And I think that otherwise you do have a situation where you would have conflict between inherent jurisdiction and the law, which would create difficulties.
But if the rules were construed as dealing with something narrower, as for example, case management powers, and therefore there would be no conflict, would you then be asserting that in any event there is an inherent jurisdiction?
Well, in that case, as I would say in this situation, my lord, that there is no rule that prevent the court assuming jurisdiction, my lord. If there are case management powers, they don't, even if there weren't case management powers, they do not conflict or prevent the court. There's no express provision when properly constituted to prevent the court from assuming jurisdiction pursuant to its inherent jurisdiction.
Mr. Brown, what's troubling me is this. The usual reason I'm not here speaking particularly of Jamaican rules, why an appellate court is given all the powers of the court below, is so that if it allows an appeal against a decision of the court below, it can substitute of itself some different decision within the whole range of decisions that the court below could have made, rather than having always to send it back to the court below.
Yes.
The trouble here is that this wasn't really an appeal. It wasn't an appeal against some decision. It was an application made in appeal proceedings arising out of the fact that it was alleged that the judgment given in the appeal proceedings had been void.
Lord.
And I'm just wondering how we cross-apply this concept of an appellate court having all the powers of the court below in a context where it's not performing an appellate function.
My lord, the Supreme Court, which is the lower court, has other, apart from dealing with judgments, they do have powers with respect to the matter, which is ancillary to the determination of the matter. So they can strike it out, they can make whatever other orders prior to trial, and if indeed, my lord, an application could be made before the court, say, to deal with bias and such things, so that it's not unusual for matters to arise during the course of a matter that the court would have to address, my lord. And I think it's very similar in this situation where during the course of appeal, a matter has arisen that affects the appeal. And just as the Supreme Court would be in a position to address that matter, the Court of Appeal, I would say with respect, would be in a similar position.
But suppose you had a situation where the claimant brought proceedings against a particular defendant. The defendant denies it's liable and says, no, it wasn't me, it was X. For some reason, the claimant doesn't actually join X to the proceedings. They get a judgment against that defendant, but on appeal, the Court of Appeal says, no, it wasn't, you didn't join the correct person, it should have been X, but you haven't joined X. Would you say that the Court of Appeal can then proceed to hear a case against the X and award damages against X, even though there's no judgment against X from which there is an appeal? Or is, because that seems to be what's happening here, that these proceedings in the Court of Appeal are against a completely different party from the bank.
That context, as explained by your leadership, the Court of Appeal would not be in a position to award judgment against the party, a non-party. But if we had a situation where there is an issue, as in this case, the matter had to do with the conduct of the court itself, and that conduct raises a constitutional matter, I believe is an entirely different situation, and that could enable the Court of Appeal to, when dealing with the matter, to make the appropriate order with respect to that matter, regardless of whether the person against whom the order was made was in the substantive claim. That's how I would respond. Yes, sorry. They know. They are aware. Write it down, Dave. Write it down. Yes, I'm sorry. So, my Lord, I think we have already dealt with inherent jurisdiction. I will move along, and your Lordship will see, especially when you read the judgment of Mrs. Justice MacDonald Bishop, where the questions were assigned, that she came to the view that the Court of Appeal did not expressly decline jurisdiction. What it did, did not say it didn't have jurisdiction, but they declined to treat with the matter. And, my Lord, for what is worth, my Lord, that is at page 373 of the record at paragraph 83. And of course, when you look in the judgment...
Sorry, can you just give us a moment to get that out?
Page 383.
So what are you showing us there exactly?
373. This is a judgment where the questions were approved by the Court of Appeal.
The questions for us?
That's right.
I see.
And in reviewing the substantive judgment of Justices Morrison, Brooks, and Phillips, this panel took the view that the court did not expressly say that it didn't have jurisdiction, but it declined to treat with the matter. And that is at page 373 and paragraph 83. Now, my Lord, you looking at the judgment now of Morrison, Phillips, and Brooks at page 254 to 257, you'll see the reasons why Justice Morrison declined jurisdiction. And he says, at paragraph 76 to 81, he accepted counsel for the Attorney General, the then learned Solicitor General, submission that it would not be possible or convenient for the court to treat with the matter because evidence would have to be given as to the circumstances that caused the judges to fail in their duty and to leave their bench without delivering their judgment. She says detailed evidence and explanation would be required, and the judge, Ms. Justice Morrison, accepted that. And you will see later that he relied on Bell and DPP, and also a case, I believe, from the European Court of Justice. The name of it is not with me immediately. Dyer and Watson, pages 254 to 256. But Dyer and Watson, with respect, and Bell and the DPP was dealing with a circumstance. I'm now dealing with whether or not the court, my lord, was correct in declining jurisdiction. And I'm submitting that they were not. They have jurisdiction and they should have treated with the matter. And Justice Morrison relied on Bell and the DPP and this other case, but both cases were dealing with circumstances where the system failed to bring the matter forward so that the trial could have been dealt with, which is completely different from this situation, my lord. And if you look at the passages cited by Justice Morrison from Dyer and Watson, one of them, the last one, set out at the page 257, number 5, sets out the systemic issues to which he's referring to, and suggested that that was not of such fundamental importance. So I can't, beg your pardon, my lord.
I'm just going, I didn't quite understand the point that you were making about the judgment of Mrs. Justice MacDonald Bishop, because the questions referred at page 374 does seem to raise the issue whether the Court of Appeal has the jurisdiction, and if so, whether it is the proper forum to hear and determine.
Yes, my lady.
So that does seem to be requiring the board to decide, if necessary, whether the Court of Appeal has jurisdiction. But I thought you were saying, oh, well, she looked at the reasoning of the Court of Appeal and decided that they hadn't held that they had no jurisdiction. She thought they had only exercised a discretion not to
It appears,
use.
my lady.
But it's accepted, I think, that the question of whether there is actually jurisdiction to be exercised
is before you.
Is before us.
Indeed.
Okay, right.
But she, in speaking generally, she suggested that it appeared to her that they did not actually say we don't have jurisdiction. But she nonetheless certified the question, my lady. So it's before you. But to the extent that they declined jurisdiction, my lady, I wanted to look at the reasons why they declined jurisdiction. And just to summarize it quickly, that I say that those reasons, that is to say you needed evidence, is without merit. And the reason why I say that is that once the court found that the judges acted outside the Constitution and they were not judges, then Section 16.2 would have been breached because there would not be a court established by law. That's the first point. Secondly,
well, it's breached because you haven't yet had a determination by a court.
that it...
So there was a purported determination after 4 years, which might have been delay in itself, but
Yes.
That was a nullity.
Yes,
And so you still haven't got a determination.
that is so. But the point I'm making is that section, once they deliver their judgment after retirement, they could not comply with 16.2 because that meant that they were not appointed under the Constitution.
Those judges couldn't, no.
And that is why I say, As a matter of law, Section 16.2 would have been breached. In any event, my lord.
But does it follow from the fact of a breach of the Constitution that no issues as to whose fault it was, as between the judges and the system, for example, are of any relevance at all in deciding whether any, and if so, what redress should be provided? I can see for myself, at least in theory, a difference between a situation in which the breach of the Constitution occurs because of some systemic structural aspect of the justice process for which the government is responsible, and a case in which it occurs due to a bona fide mistake made by a judge.
And I would answer it in two parts. I would say it would have made no difference for these reasons. One, those reasons and issues cannot be considered because they had to be judges in the first place. That's what Section 16.2 requires. Once they were not judges, there was a problem. The second part of it, my lord, and I say respectfully, if the court, it's a different situation where a party is complaining that his trial took a long time. And so you have to consider various matters, his own conduct, and so on. Systemic issues, probably. Why? And I would say even in those situations, systemic issues are to be considered guardedly because he has a constitutional right. The state is required to ensure that the rights are not breached.
But suppose that there hadn't been any delay and there had been a prompt hearing, but it had turned out that the judges who decided it were not recognised as a court, and therefore it was a nullity. That wouldn't in itself be a breach of 16.2, would it?
It would be.
Why couldn't, if there could be a rehearing before another court soon, then you would still have got your fair hearing within a reasonable time by a court, even if the first attempt was a failure.
In that situation, the remedy for the breach is a matter of remedy that your lordship is now referring to.
No, I'm questioning that there would be a breach at all of your constitutional right just because the hearing was a nullity. If there could then be a second hearing promptly afterwards, then that you would still have got your fair hearing within a reasonable time by an independent, impartial court, even if the first attempt failed.
Respectfully, I would say that it is the remedy for the breach would be a retrial or a trial or a new hearing, but the breach would have taken place because the requirement is that there must be judges and there were not. So that is a breach.
So the breach would have been because there was a hearing, but the hearing didn't comply with the Constitution. With the Constitution, yeah.
As a matter of law.
But at the time of the hearing, they were judges.
At the time of the hearing. But when, you see, the judgment is fundamentally a part of the process, my lady. You can't have one without the other. There's no justice without the judgment.
No, it's part of the hearing, undoubtedly, the judgment.
Very well, my lord. So that's how I'd answer the question. But I want to finalize the position to your lordship in relation to, in the situation, whether the question of facts would be relevant. Well, whatever the explanation of the judges, my lord, we made a mistake. We are sorry. Whatever would make no difference to the citizen. Mr. Justice Brooks, at the beginning of his judgment, lamented and suggested that it is systemic. He did. It was a problem. But in relation to the citizen, the state is supposed to fix that.
May I ask you this? This may be said to be quite an extreme case, but where does one draw the line if errors in the court system lead to the parties having to incur costs? Supposing the parties lodge a file and that goes missing, or a hearing has to be rescheduled because of because a judge falls poorly, and as a result the parties incur costs. So far as there is a deficiency in the system, can the parties recover for breach of their constitutional right? And if not, why not? Where does one draw the line between that sort of a case and this sort of a case?
If it is that the file is lost, unfortunately, that's not an unusual situation. And files...
Take it a little bit further. The file is lost through the negligence of a court officer.
Yes. But file could be lost for years, as happens. It depends on the circumstances, my lord. Because the file can be reconstructed, but if the file is lost and nothing happens for 10 years.
It's a question of delay, is it, that matters, or is it a question of the degree of the deficiency which leads to a greater or lesser inconvenience and cost to the parties? My question to you is what sort of principles does one apply in deciding which side of the line any particular case falls?
I would say that it depends on the steps taken by the authorities to remedy the situation, and whether that remedy was effective.
Well, it is effective to a degree, but the parties have still incurred costs. Who pays the costs?
The state, if there's a breach of the Constitution.
Oh, that's my question. What constitutes a breach of the Constitution? If there's a deficiency in the court system, that's a result of negligence, which leads to the parties incurring more costs. Is it your submission that in every case of that kind, the state is obliged to pay because there is a breach of the Constitution?
My lord, in every case. It depends on the effect. It's one of those creatures that you see, when you see it, you know it.
Well, what characteristics of the creature enable us to know it when we see it?
Well, as in this case, where there was no judgment as a result of the conduct, and the length of time, in this case, where the courts, our courts, meaning the Court of Appeal, has said that judgments are to be delivered within 6 months. And in this case, it is 4 years. So that's the next point I was going to make, that the Court of Appeal previously has said that a delay of 3 years is outrageous. It's unreasonable.
I can quite see your point that once you establish a breach, then the reason for the breach may be irrelevant. But what if, for example, a delay in the hearing of a case was caused by the court building and all its records being destroyed in a hurricane, and it taking years to get them rebuilt or somewhere else to be made available for a rehearing? Now, would that on the face of it would be a breach of the Constitution, because the litigant wouldn't have got his hearing within a reasonable time. But nobody would blame the state for it, would they?
So he may then be entitled to a declaration and nothing else.
So it may affect the nature of your remedy?
It may affect the nature of the remedy.
Right.
I've made that already. My lord, I will just quickly...
Could I just ask, so at one point in your submission, you were indicating that because the judges were not qualified to act, that itself was sufficient.
I say that.
And therefore, one doesn't need further evidence.
That is so.
Because that's clear cut.
Yes.
But you also then linked it to saying that if that happened quickly, there may be difficulties in establishing the breach of the constitutional right, and that therefore what was important in this case was the linkage between the delay and the fact that the judges weren't qualified to act. Now, if that's the case, we go back to the problem that we need evidence to deal with the reasons for the delay, I think.
My Lord, what I would say is that in that situation where the judges are not judges, then the breach is immediate. And in every situation, the remedy that may be appropriate would differ.
Well, if the remedy would differ in a case where there's no dispute that there was a breach, is that not likely to lead to a forensic examination by a court suitably equipped to look at all the evidential matters relevant to the question as to what kind of remedy the applicant should obtain? Even though breach itself is not an issue.
It could be, my Lord, but I say that in this case it doesn't.
Okay.
The matter was clear, my Lord. But
sorry, just because we're trying to identify the principles, do I understand you to be accepting that if evidence were necessary, it would be appropriate for it to go to the Supreme Court, that is to say, the High Court?
my Lord, that if when you look at Silver Creek, you will see that His Lordship, I don't remember the name of the judge, Sir Linden, indicated that whether the court assumes jurisdiction will depend on the justice and fairness to the parties at the time. So I would be to say that there would be occasions where it may be appropriate to send it to the Supreme Court. I'm saying that in this case it was not appropriate.
Or not necessary?
Or necessary.
You say that, as I understand your submission, that the breach is so clear because of the 4-year time and the lack of qualification at the relevant time of the judges.
But I want to add another reason why it is inappropriate, my Lord. When it comes to fairness and independence, my Lord, when you look at section 106, that entire section, and 107 of the Constitution, you will see that it sets up certain protection for the judges. It is very difficult to remove a judge of any court, high court in Jamaica. It requires an appearance before this tribunal. Salaries cannot be affected. So those protection, and I think your Lordship, while it wasn't cited, would remember the case of the Independent Council for Human Rights against Marshall Burnett. That, my Lord, was a case that came to this board where the government of the day passed a law to move from the Privy Council to another tribunal. The higher court had none of the entrenchments that the lower court had. And the Privy Council held that it would be unconstitutional to have presiding over a court that is protected, another court without the same protection. So the point I'm making is that these judges had no protection. It is the protection that guarantees their independence and the fairness. And that's another reason, my Lord, why I submit that there was a breach.
So you say that their lack of security of tenure imperils their impartiality, perhaps, or their independence.
Indeed. So, my Lord, I think that I may, having regard to time, may have to move on.
Yeah.
I was hoping your Lordship would say no, but...
Don't feel that it's time wasted.
No.
Mr. Graham, it's been most helpful.
Very well. Then, my Lord, you'll recall, my Lord, that there is an argument that to make an order against a judge, sorry, not a judge, for the state to be responsible for the conduct, so to speak, of a judge is a problem insofar as the judge is not an agent of the Crown, and that it affects the principle that a judge is not liable for acts done while he's a judge. Well, my lord, I cited the Maharaj case that specifically deals with that the Privy Council in that case says it is not a vicarious responsibility. It was a direct responsibility of the state. And when you read it, when I read earlier, my lord, section 13, I think 2, it says no organ of the state shall do these things, breach these rights. And the courts cannot be held to be exempt from that general principle because it is an organ of the state.
And that's Maharaj and the Attorney General of Trinidad and Tobago.
Indeed, my lord.
Yes.
And, my lord, I had planned to go through some of the passages.
Thank you.
Well, I should. Very well.
We can obviously read them if you tell us what they are.
I understand.
I'm conscious that your time is not, is not in your favor.
Yes. May I then refer you to pages 877G to 878B. It is one of the older cases, my lord. There are no paragraphs.
Yep.
Crave indulgence. Also, my lord, at page 880, letter H to 881A. As examples. There are other examples where the matters are discussed, but those are some examples. And I would crave indulgence before I quickly move on to the next point.
You say these are enough to establish that the behaviour of a judge can constitute a breach of a constitutional right?
Will you repeat that, my lord?
The behaviour of a judge or the deficiencies of a judge can constitute a contravention of a constitutional right.
Yes, my lord. Yeah. No, Lord de Black points out that he himself is not, or she, being asked to do anything. It is the state that is being asked to do it. So his immunity remains intact. But the state is responsible. Unless the judges are going to declare independence and say we are just out there by ourselves, the Constitution, we only apply the Constitution to everybody else, and we can do as we please. No judge, I think, would want to suggest that. I would then move on to the other two questions. Mm-hmm. Quickly. My lord, may I tell you quickly that we did send up some supplemental cases.
We have those.
Because those are cases subsequent to Maharaj. All of them, Maharaj, of course, was a contempt matter, and the three cases in the bundle are criminal-related matter. And what I would say, and I just tell you that these judgments affirm, my lord, that in appropriate circumstances, the court will consider whether the process or the system was breached the Constitution, provided that the matter is not a matter that was dealt with on appeal, or could have been dealt with on appeal. You would recall in this case, Mr. Justice Morrison found that there was no effective means of appeal in this case, and that's one of the reasons why he assumed jurisdiction, and he explained it, my lord. But those cases, I won't go into them unless I probably could just tell you, my lord, what they say on the pages. Forbes against the Attorney General of Trinidad and Tobago in the supplemental bundle of authorities, page 28 to 34, particularly paragraph 18, and that reviewed the prior cases and says that the cases establish, even though it happens in only rare cases, that where there has been a fundamental subversion of the rule of law, resort to constitutional redress would likely to be appropriate. And we consider that this situation is a fundamental subversion of the rule of law. And of course, similarly, if you look, my lord, at page 854, that's where Budram was cited. I don't want to tell you what Budram said. It is set out there, my lord. And similarly, Forbes was referred to in Hines, my lord, at paragraph, sorry, my lord, what page did I give you?
You gave us 854.
I think that I am
Can't be a
incorrect.
supplementary bundle.
It's at paragraph 16 of the Forbes case, my lord, and that is at page 28 to 32, I think. And then similarly, 34, there's also a reference to Hines,
Yep.
also at page 28 to 34. So I would leave that, my lord, and just summarize the other 2 points, relying on my submissions, the case. The second question, my lord, is to be answered in the affirmative in our submission. It is an independent question. It is not the issue there is not the charter rights, my lord, because the charter rights have a specific appropriate form of redress. But there are other provisions of the Constitution, which is Section 106 is one of them. And one of the things that Section 106, that entire section deals with, is that judges are to be appointed and they ought to retire. Therefore, a citizen has a right to obtain a judgment.
Where do we find that section? Sorry, can we have a look at it?
Section 106, my lord.
Yeah.
I had mentioned it earlier.
Oh, sorry, that just simply says that's the retirement requirement, is it?
Yes.
Oh, see.
And the prior section.
But that doesn't give a right to anything, to the citizen.
Well, the sections before that deals with the appointment of the judges and so on. It does, my lord, with respect, give a right to the citizen. That it means, when properly interpreted, that the citizen would be entitled to a judgment from a judge who is not retired.
You're not arguing, are you, that Section 106 gives rise to a right to damages if a judge who's not retired sits on a case and costs are wasted?
Yes, my lord.
You are making it.
I am making that point.
Well, the statute would need to say something along those lines.
I would say, my lord, by necessary intendment. When it doesn't say it, but my lord, the cases cited under my written submission shows that citizens are entitled to come to the court if any other section of the Constitution is breached. Bear in mind the fact that it is a superior law and the fact that the court is a court of record. All of that, my lord, is set out there. And if that constitutional breach costs loss, why shouldn't he not be given a remedy?
But what is the constitutional breach here that you're saying has caused the loss?
The constitutional breach, I would say, that caused the loss, my lord, is the delivery of a judgment by persons who were not properly appointed under the Constitution.
But is this separate from your Section 16(2)?
I believe it is, my lord.
Right.
It is a separate but related issue. but I believe that it can be dealt with. If there was no section 16, I would be making the point on section 106 only.
But given that we've got section 16, it's not clear to me that this is really adding anything. It seems to me to be explaining more fully why these judges were not judges.
But that is assuming that your lordship is going to agree with me in relation to section 16. If there's no agreement.
But what if, presumably, the Governor General does not have to give permission to the judge if the judge requests to continue? And one can imagine an unfortunate situation where the judge wants to continue after the age of 70, but the Governor General says, sorry, you're not really as sharp as you used to be, and it's not appropriate for you to continue in office. And it may be that as a result of that, the judgment can't be handed down. Now, has there been a breach of Section 106 in those circumstances?
Yes, my lady, there is a breach because they would have retired. The judgments, the effective requirement is that you serve until you retire, unless extended. If you are not extended, you are not a judge. You can't then go and deliver the judgment.
But it's not, is it the delivery of this void judgment that caused your loss? It's the non-delivery of a valid judgment within a reasonable time, and by the same judges upon whose ears you spent costs conducting an adversarial hearing.
That is a good way to put it, my lord, but that's not the only way, my lord, because, and I accept that way as a particularly in relation to the first question, but if it is that the judgment, the case was heard today, and I retire at midnight, and I deliver the judgment tomorrow, maybe there will be argument about de facto officer and so on, but putting that aside, I would still have delivered a judgment that is not a judgment.
Yes.
And therefore, the Constitution would have been breached.
But that doesn't follow. The fact that somebody doesn't have power under the Constitution doesn't mean that there's a breach of a infringement of a constitutional right.
If it is, as in this case, where I'm dealing with this particular case, the court found that in the circumstances where the judges have been retired, their position filled by other judges, then it would be, I respectfully submit, be a breach.
But it isn't. There's nothing in 106 which imposes a duty of which there's a breach. It's simply a lack of power because they failed to get the authorization they would have needed to continue in office. But there's nothing in 106 that gives an obligation on the state towards the citizen of which the state is in breach.
So, my lord, put in the fact that, as my lord puts it, that the 216 and the 106 is connected.
Well, you'll make it as a separate submission.
That's a separate
I understand your submission under 16, but you're saying that independently of that, there's a breach of 106, and I cannot find in 106 any obligation owed by the state to the citizen of which there is a breach. It's simply a matter of a failure of the judge to get to have power.
The obligation of the state in that situation, my lord, is to constitute a lawful court.
Where does it say that in 106?
I say it doesn't say it expressly, but when you read it, my lord, it must follow, we say, with respect.
Well, I think we've got the point, Mr. Brown. I'm worried about your time frame.
And the last.
Do you want to say just a very few words about your third question?
The third point, my lord, I would say that, your lordship, the rules permit the court to award costs against a third party, so long as that third party has notice. And citing the Privy Council case of Dimax, I believe, there are cases where there are specific examples. Those are just examples. The real test, as Justice Brooks accepted, is whether the justice of the case requires it. Justice Brooks said that there was nothing, it's not unusual the word he used, my lord, and I think nothing particular, there was the circumstances of this case did not warrant the imposition of the rule. But if justice in this case, in the context where Mr. Chen-Young, and your lordship will recall, accepted by Mr. Justice Morrison, is unable now to go and do his trial, his appeal all over again. And if you look at the judgment of Mr. Justice Panton, the impugned judgment, the appeal lasted 18 days. When you look at the total circumstances of this case, I would say that the justice would be properly requiring that the third party bear the cost.
Yeah, thank you.
I'm obliged.
Thank you very much indeed. Now, I think we have Mr. Hilton next.
May it please you, my lords and my lady. In the circumstances, my lords, I do not propose to make any oral submissions and will rely merely on our written case.
Well, thank you, Mr. Hilton. That's commendably brief. I think we'll probably, in that case, take our 10-minute break now, and then we will hear from Mr. McCoy in response thereafter. So it's now, on that clock, about 8 minutes past, and we'll resume at just before 20 past. Thank you very much. Yes, Mr. McCoy.
If it pleases you, my lords and my lady, I'm Derek McCoy, and I appear for the interested party. With me are my learned friends, Miss Annalisa Lindsay and Miss Lisa White. My lords and my lady, I hope I'm not trivializing the appellant's case when I say that, in essence, it appears that the principal questions before you are whether the interested party should pick up the appellant's cost for an impugned hearing of the Court of Appeal, first of all, and secondly, for a motion before the Court of Appeal applying to impugn that hearing, and secondly, resolving several issues of dispute between the parties, between the appellant and the respondent, on orders from the first instance judge on matters that we had no interest in and no participation in, but somehow it seems we're also entitled to assume responsibility for that. The formal issues, my lords and my lady, are set out in electronic bundle, pages 519 to 521. The interested parties case is set out at page 557 and the following pages. And we will not unnecessarily repeat any of the information that we've already said. We'll try to rely as much as possible on the stated information, the stated case. But with your permissions, my lords and my lady, I wish to address you on the first two of the Court of Appeal reserved questions, questions A and B, and some other issues which the appellants have raised, which are related to those two questions. And I'll call these, if I may, the constitutional questions, the constitutional matters. And with your permission, my learned friend, Ms. Lindsay, will address you on the third Court of Appeal reserved question and associated questions, which I believe the Court of Appeal below addressed as the cost issues, if you would approve. My lords and my lady, it's not a perfect division of labor, but we will try not to encroach too much on each other's responsibilities, and we promise, of course, to finish within the allotted time. If I may begin first by addressing the Court of Appeal's reserved question issue A, which is the appellant question 1, I think. And I think one may look at it, my lords and my lady, in really two parts. The first part, really, is whether the Court of Appeal has jurisdiction to hear and determine an allegation of a breach of a constitutional right. And the response must be an emphatic yes. This cannot be a contested issue. And that there is almost unanimity on this point among the members of the Court of Appeal, with the position, I believe, of the interested party from the very beginning, for which is allowed to participate. And indeed, my lord, it has been a settled legal position in this jurisdiction for at least 4 decades, on the authority of a case from this court. So there's no question that the Court of Appeal has jurisdiction to hear and determine an allegation of a breach of the Constitution. Clearly, to do that, if the matter arose before it.
But that's not the question in this case. The question is whether it has the jurisdiction to determine an allegation of breach raised during the course of the appeal and that it did. Oh, of course, everybody knows it has general jurisdiction to where a question of breach of the Constitution comes up. Yeah, the question is focusing on the way in which it did come up.
Yes. My lord, if the Court of Appeal is addressing a matter on appeal, then the uncontested point is clearly it has jurisdiction. To raise a question in this manner, we would suggest, is not appropriate. But even if it were, even if the Court of Appeal had jurisdiction to address this matter in this way, it is not obliged to do it. Because one has a power does not mean that one is obliged to exercise that power. It's well recognized that the authority in the normal course of events resides with the Supreme Court. And may I just make the point to address very clearly, because there's some suggestion that it might be shared authority. The authority of the Supreme Court is not shared. It cannot be. When it declines to hear a matter, because it recognizes the matter may best heard not as a constitutional matter. It doesn't share jurisdiction. So the best place, if that matter is to be heard at all, is in the Supreme Court. And if you'll allow me, my lord, if I may just direct your attention, if I may, to the judgment of Mr. Justice Brooks Justice of Appeal, at the electronic bundle at page 301, at paragraph 178, where he accepts the Court of Appeal may provide the redress, but thinks the Supreme Court is better able to do so. And at paragraph 179 of his judgment, that the first appellant's evidence requires evidence in response that had not been adduced, and that the Court of Appeal should decline to deal with the issue. I could go to that in some detail if your lordship, and lady wishes.
Well, what would be helpful is if you could give an indication of the kind of evidence that could possibly be relevant in this case, that goes beyond what is known already.
Yeah. We do not know, and we cannot know the circumstance. If we're to say the state's responsible, the circumstances which accounted for this delay, we really do not know. Is it an administrative error?
What difference does it make what they were? I mean, what sort of circumstances might make a difference, would you say, that would improve the state's position?
There's the broader issue as to whether someone's entitled to a fair hearing within a reasonable time. It's a matter of dispute, and I'm not suggesting it's so here, whether in fact 4 years is reasonable circumstances. But if you may account for it as a purely judicial act. You may account for it as maladministration. I would suspect in the latter case, if there's maladministration, the state has responsibility. If they're pure judicial acts, the state would not be responsible.
Sorry, what would make the state not responsible?
If it's a pure judicial.
If it's just the judge's fault, the state isn't responsible for that.
Yeah, I would think not, my lord. So if it's purely
so if a judge just sits on a case for 10 years, then there's no breach of, if it's just the judge's fault, there's no breach of the Constitution on your view.
No, my lord, I would think that that's clearly a breach. The judge sits in a matter for 10 years. But how is a judge allowed to sit in the matter for 10 years? There may be
4 years then. Well, let's say 4 years in this case. Why isn't that an obvious breach? Of course, at the end of 4 years, there was no judgment anyway, so it's still time's still going. But why isn't 4 years delay an obvious breach of the right to a hearing within a reasonable time? We're not talking about a breach which includes time which the parties might be responsible for. This is just the judge taking 4 years before they produce a judgment.
I think, my lords, that everything must depend on the circumstances.
Well, what could possibly excuse a 4-year delay by the tribunal? I mean, if there was anything, you'd expect them to say so when they gave the judgment, and they don't.
Yeah.
If one of the judges had been ill for 4 years, then they would have said so, no doubt.
I think my friend had mentioned the difficulties of these circumstances. If your lordship will reflect on the judgment in the Court of Appeal, you will remember that there's a suggestion that there is a difficulty, a tendency, an unfortunate circumstance where judges are delayed in delivering their judgments because of perhaps lack of resources.
Well, that makes it all the more the state's fault then, if that's the reason.
Well, if a court wishes to hold that the state is at fault for not having adequate resources and not applying adequate resources to the judiciary, then the court may very well do so. We would suggest that is not necessarily the right approach. One would have to make an assessment whether the state is applying the resources as best it can in the circumstances. The practice, we are told, especially if you reflect on Mrs. Phillips's judgment, that judges in this jurisdiction have had to resort to delivering judges in a slow manner, and have had developed a practice of delivering judgments after they're retired.
Well, in the judgment of, forget which of the Court of Appeal judges it was, but on page 256 of the bundle that we've got, quoting from the case of Dyer and Watson and the judgment of Lord Bingham, Obviously, it's an analogy with the similar provision of the European Convention on Human Rights, but on 256, para 55, and that which is quoted there, as I understand, with approval by the Court of Appeal, that refers to the fact that states cannot blame unacceptable delays on a general want of prosecutors or judges or courthouses or chronic underfunding of the legal system. It's generally speaking incumbent on states so to organise their systems as to ensure the reasonable time requirement is honoured.
Yes, my
Do you
lord.
agree with that as a matter of interpretation of the Jamaican Constitution?
I would, my lord. I would. But may I just bring to you the further consideration, which I think might have been addressed earlier. My lord, by one of your members, I think by Lady Rose. We, in these particular circumstances, we can't account fully on the evidence for the delay. We do not know if the matter was brought to the Governor General's attention and not accepted, or since you're so glibly speaking of maladministration, but the matter might have got lost in the Governor General's office. But the judges are happy to rely on the tradition they have had. We do not know the full state of affairs, and these matters are matters that ought to be inquired into. This is a point that I think Mr. Justice Brooks made, that one needs the evidence to address these issues, and he's not able, in his circumstances, and I would think he's the best person able to address that issue, to make that determination.
May I ask this question? Would you anticipate, would you expect to put in evidence on these questions if the matter were to be remitted to the Supreme Court?
It is a question, we would think, my lord, for the appellant, now the applicant. They will determine what issues they want, and the state would have to respond and address it.
Well, they're not suggesting they want any evidence.
I beg your pardon, my lord?
The appellant's not suggesting they want any additional evidence, so I think it is for you, in answer to my Lord Kitchen, to indicate whether you would be proposing to adduce some.
If this case came before the Supreme Court, then the interested party, then the defendant would have to respond and would find what evidence is appropriate. We would need to find some explanation. There can't be a denial that 4 years intuitively is a long period of time, and one that's not readily justifiable. But the honest wrongs, we do not know the circumstances. My lord, if I, may I go on, my lord?
Thank you.
Yes, please.
If I may direct your lordship's attention to an earlier point. I think this point was raised, if I'm correct, on the issue D and M by the appellant. And there's some issue as to the validity, if that's the correct term, or the nullity of what we're now calling the impugned hearing. The questions I believe asked was whether the hearing, first hearing, the impugned hearing, if that was a nullity, I think. And the second, whether it's a matter of law, a matter of clear nullity, there should be no order as to cost. Now, I'd like to start, if I may address that issue, because it makes distinction, my lords and my lady, if you're making a distinction between the hearing and the actual judgment. And I think the implication here is that the hearing itself was not defective. It's a judgment that was not delivered that was defective. But the important issue on this point, that this is a decision by this Court of Appeal. This Court of Appeal decided that it would impugn or nullify, if you wish, the hearing and nullify the judgment. In a sense, it's given the applicant, the appellant, the remedy that it says almost asks for. But the judgment, the hearing by itself is not inherently defective. The judges were properly appointed when they heard it. And the judgment they give, there's an argument made very clearly by Mrs. Justice Phillips, that judgments like these are in the past were probably acceptable. If I could, she based her arguments, I believe, my laws on the de facto officer doctrine. And if I could direct your attention to the electronic bungler 268, page 100, paragraph 106 of her judgment, which seeks to justify the circumstances, a judgment in these circumstances, which is delivered late and delivered after the person has in fact become functus, as something which might have been appropriate and which in fact might have operated in the past. But the critical issue to note is that that court which is given that judgment was given, is now impugned, if you wish, by the Court of Appeal, by an act of the Court of Appeal. I'm not asking your lordships necessarily, well, I would ask your lordships to accept Mrs. Justice Phillips' view of the situation. But there's another issue which I think is relevant, which supports our argument. The question is whether a judgment given after the judges have retired becomes completely, if I may use the term, worthless. And she's suggesting it's not true. But there is, my lord, an issue as to what you understand by the section 106, subsection 3 of the Constitution.
I thought that was decided by the Court of Appeal, and there's no challenge before us to the conclusion that it was a nullity, the hearing.
Yes, the Court of Appeal made that decision, and we contend that they have the authority to do that. But that is their decision. They made that.
Well, exactly. So the starting point for us is that there's been no provision of a valid hearing at all to the parties.
But, my lord, I think you cannot, with respect, make that determination only ignoring the discussions the judges had in the Court of Appeal. I think you can't simply ignore Mrs. Justice Phillips's judgment. She acknowledged she'd acquiesced with the majority judgment, but she did spend significant time discussing how judgments of this nature ought to be treated. And I think, my lords, with respect to, one should consider what she had said in this matter.
Whether or not the hearing was a nullity, you must, well, do you accept that once the judgment is a nullity, then there has to be a rehearing? You can't have 3 new judges, for example, reading the transcripts of the appeal and then coming to a view on the basis of a hearing that was conducted before 3 different judges, can you?
No, my lord, I'm not suggesting that at all. I was answering, I thought, a different question. The question was, when we resolve this issue, I didn't think it would be appropriate, with respect, to simply ignore what Ms. Justice Phillips had said as to how this jurisdiction has treated these matters in the past. She deferred to the majority, but this is not to say she hadn't offered us a considered opinion.
I don't see what the relevance is.
So the fundamental issue, my lords and my lady, is that on this issue, the Court of Appeal has a discretion to nullify the judgment, as that's done, to grant a remedy, which is a rehearing of this matter in it. It's not obliged to consider the constitutional question. It may defer them if it wishes. It recognizes that these matters are best heard by the Supreme Court. And the Supreme Court, of course, will provide a remedy, whatever that is, whether it be damages or whatever, will provide a necessary remedy to the claimant when it's made. The fundamental issue is that the Court of Appeal is not obliged. It has a jurisdiction, but it's not obliged to exercise the jurisdiction if it thinks it's better than exercised by the Supreme Court. It's not compelled to exercise that function. It may, but it's not obliged to do so. And in its considered opinion, it decides that this matter is best heard by the Supreme Court. And it has granted granted the appellant the remedies appropriate in this case, a new trial, recognizing that other remedies they may choose to exercise. And just for the record, my lord, I wish to just indicate that we're not contending that for a delay of 4 years it was on principle and necessarily a fair hearing within reasonable time. But it we suggest it could be a contested issue. It's an issue which could be contested in the Supreme Court.
Well, of course, it's more than 4 years because if we're looking at the delay point, has there been a rehearing yet?
To the best of my knowledge, my lord, no. We're pursuing this appeal at this point.
Yes.
Yes, so that you may make better use of our time, my lord, which we have to share. If there's no other question on these points I've raised, and the matter raised in our case,
I would just like to be absolutely clear as to the attorney's position. Looking at page 374 of the bundle and the first question, which is before the board.
Page 774, my lord, my lady.
374.
Yes, sure, just a minute.
Paragraph 85 of Mrs. Justice MacDonald Bishop's judgment. Now we had an exchange with Mr. Brahm about the scope of that question. And he said that it raises two issues. That first line of question number 1 raises two issues: whether the Court of Appeal has the jurisdiction, and if it has, whether it was correct in exercising its discretion not to hear the constitutional challenge.
Yes, my lady.
Right. Now, as I understood the submissions you've just made, you are conceding in this case that the Court of Appeal does have jurisdiction, and you're only arguing the appeal on the basis of whether they rightly exercised their discretion or not. Is that, have I correctly understood your position?
That's our current position. We have, May I present judges, my lady?
Sorry? Can you? Oh.
I think your sound has gone off. Oh dear. What's happened?
You lost the connection.
Prevent indulgence for a moment, my lady. Let me sort some matters out, please.
Oh, I think he wants to take some instructions. Right.
Rise for a moment.
Well, let's see how we get on.
Very, very important.
He's left the room, effectively.
Maybe the connection's gone.
You've just been told off.
I don't think so.
I'm terribly sorry, my lady. I think I've got it sorted. The question you're asking is whether the Court of Appeal has jurisdiction as a general rule to hear constitutional matters.
No, not as a general rule.
In this case.
In this case, did the Court of Appeal have jurisdiction in this case, in the hearing before it, to go on and hear and determine the constitutional challenge to the potentially hold the Attorney General liable to pay compensation for a breach of the constitutional right?
Our position is that raising this matter in this manner is inappropriate.
That's not the question I'm asking. I'm asking, and it's an important question, whether you accept that in this case, in the circumstances of this case, the Court of Appeal could, if it had so wished, have exercised jurisdiction in deciding the constitutional claim.
No, my lady.
Are you saying you don't accept that it had jurisdiction?
In this particular case.
Well, so far all your submissions have been that it was exercise of discretion was justifiable. So if you're arguing that it didn't even have the power to have done so, it never should have got to discretion, then you need to explain why.
There are two separate issues, my lord. The first issue is the general power of the court, which we suggest is not contested. The general power of the court to hear matters on appeal, which have been written on appeal.
Right. Yeah.
Yes, so that matter is not contested. But this is not a matter which is arisen on appeal. This is a matter in which a person has hitched to another issue, a matter which is completely foreign until this moment. It's not an appropriate way to raise a constitutional matter in the Court of Appeal in this way.
Right. Well, do you say that because there was no Supreme Court decision on this point, that therefore, as an appellate court, the Court of Appeal did not have jurisdiction to determine it?
Let's listen to.
No, the evidence, the laws as we have had it, my lady, is that if the Court of Appeal can consider a matter which was not addressed in the Supreme Court, if it arises naturally on the application, on the appeal. This does not.
Well, why do you say this does not arise naturally, is the word you used?
Yes. Well, the issue we have here, is the issue we have before you is whether the applicant is entitled to recover his costs from an interested party who was never involved in litigation until this very moment. We are brought in, it seems, to take up the expenses, which were not part of the litigation. It was an issue raised before us. It was an issue we've had a chance to address until now. And it's a device, it seems, a gadget, if you wish, to bring this matter and to impress on us this responsibility.
But those are reasons why it might be a bad idea to exercise the jurisdiction. None of them is a reason to saying that there isn't a power under the law to entertain the application.
Say again, my lord, I didn't hear that.
The reasons you've given are reasons why it might be a bad idea for the Court of Appeal to exercise the jurisdiction. You say it would be unfair to the Attorney General.
Yes.
What is the reason for saying that they don't have the power at all, other than your assertion that it didn't arise naturally on the appeal?
I'm not sure I understand the question, my lord.
No, well, all right. I think we may have pressed it as far as we can.
Yes. Please move on. Mr. McCoy.
So, in the interest of time, my lord, may I, with your permission, my lords and my lady, hand the matter over to my colleague, Ms. Lindsay, who will address you on the question of cost. With your permission, we'll change chairs.
Yes, please do. Now, Ms. Lindsay, you're going to address us on the costs question, which I think is question 3, isn't it?
That is so, my lords.
Thank you. Please go ahead.
May it please you, my lords, we are content to rely on the written submissions made in the interested parties case, and just to highlight, my lord, that the issue or the granting of costs in any matter is not one that is one of right, but one that is in the discretion of the court. So yes, usually the guiding principle is that costs are awarded, goes with the event, and so the successful party would be usually entitled to their costs. So we look at the context in which the application was before the Court of Appeal. There was a motion to have the judgment that was delivered December 2017 as a nullity. And that particular question was not contested by the Attorney General. Their contest was to whether it is that they ought to be liable for the costs. And it would be our simple submission, my lords, that it was well within the power of the Court of Appeal in hearing submissions from both parties to decide, as they did, that there would be no order as to costs. So on that basis, we believe that the exercise of the jurisdiction of the Court of Appeal judges in that matter was reasonable and not susceptible to being overturned before you.
So that deals with the cost of the application for the declaration that that the judgment was a nullity.
That is so,
right. And you say that although that declaration was made, and so one might think that Mr. Chen-Young had been successful, in fact, as the attorney didn't contest that, the main argument was about matters on which Mr. Chen-Young was not ultimately successful.
I didn't hear the last part of that.
That in fact the contested matters were decided in the Attorney General's favour rather than in Mr. Chen-Young's favour.
That is so, my lady. I would join you in that submission, although it's not a submission, but I do agree with you.
But the real question raised by question 3, the Court of Appeal's question 3, is not, I think, the costs of the motion, but the costs thrown away at the now abortive and quite lengthy hearing of the appeal before the now retired judges.
I would submit that it was both together. It was on the nullity hearing and also in relation to the substantive appeal.
Yes.
And in response to that, my lord, we submit that it was within the discretion of the Court of Appeal to rule that the Attorney General not be liable to pay those costs thrown away. And when we look at the reasoning in Justice McDonald Bishop's judgment that posed the questions to this body, she had indicated that the issue of cost was intrinsically attached to the constitutional issue, which perhaps ought to be, based on what was said by Justice Brooks, was a matter for the Constitutional Court. So the cost thrown away against the Attorney General in a matter, in the substantive appeal, in which they were not just not a party, but had absolutely no interest in it. It was open to the Court of Appeal in the exercise of their jurisdiction not to grant that order, and we would so submit. The appellants were granted not just the order on the nullity, but an order had been made that there ought to be a rehearing of the appeal. And so issues in relation to costs for the substantive appeal could there be raised between those necessary parties, my lord.
Thank you. Is there anything you want to add on that question?
Those would be my very short submissions, my lord.
None the worse for its brevity, I assure you. Thank you, Ms. Lindsay.
Obligated.
Any questions? No? I think we can now move to hear from Mr. Braham in reply. We're doing well on the timetable, Mr. Braham. But that doesn't give you carte blanche to go all the way up to 4 o'clock.
Very well, my lord. I will try to address some of the points raised by my friends, starting with my friend, Ms. Lindsay. It is accepted that the question of costs is within the discretion of the court. But that discretion must be judicially or properly exercised. The real issue is whether in the instant case it was properly exercised. Having regard to the evidence of the financial condition of Mr. Chen-Young, having regard to the conduct of the court in the matter, why Mr. Justice Brooks says that the circumstances was not exceptional. But this is indeed an exceptional circumstance. And therefore, it is my submission that the discretion was wrongly exercised.
You're talking about the costs of the appeal, not of the application.
Both, my lord. Yeah. Both. Because your lordship will remember that the application was filed before the judgment was delivered. No judgment was delivered after 4 years and after retirement. And when the motion was filed, you will see, my lord, if you look in the record, that the motion at the first page is a notice of motion, which is at page 5. And you'll see that it says simply that the hearing of the appeal number 39 of 2000, which ended on November 8, 2013, be vacated and be heard de novo. That this honorable court do fix a date for the de novo hearing of the said appeal. That the cost of the hearing of the appeal thrown away be refunded or be paid by the second appellant by the Attorney General for Jamaica. So then the matter came on before the court, and the court said, oh, by the way, there's going to be a judgment. So we are not going to hear this application. A judgment was then delivered on the 1st of December, about a week later or two. And then, subsequent to that, an amended motion now was put, which is at page 203. So the application apparently, in my submission, triggered the judgment. And so at page 203, you'll see...
How did Mr. Chen-Young know that they had not applied under section 106(2) for permission to continue?
There are two reasons, my lord. One reason I would imagine is that those are matters that are published in the Gazette.
Right.
And that's one. And in any event, Mr. Justice Panton, well, retired Justice Panton, in his judgment, sought to give some kind of apology at the end of the judgment for the delay. And he did not say, my lord.
But you hadn't had the judgment by the time you just told us,
that.
yes.
But I'm just confirming now that by the time he then gave his judgment, the impugned judgment, he gave a kind of explanation and did not say, oh, we had applied and the Governor General declined to give permission. So I will put those two together, my lady. And so that's my response to Ms. Lindsay's, my learned friend, Ms. Lindsay's argument. My lord and my lady.
But as I understand it, the difference between the application, the costs of the motion to set aside the hearing and the costs of the abortive Court of Appeal hearing, it's only the latter which would amount to a third-party costs order, because the attorney was a party to the notice of motion. So I'm not sure that the exceptionality test applies to all of those costs. I think it only applies to the costs of the Court of Appeal, the abortive Court of Appeal hearing.
I differ from your leadership in this regard, because let us assume that the matter was one of those matters that you had a litigation funder and had taken great interest in the matter, prosecuting it, not persecuting, prosecuting it to his own advantage. And that's the appeal itself. An application on the appeal could then be made that litigation funder Braham bear the costs. I am saying with respect that when it came to this matter, it was very similar, because the cost that was occasioned was due to the conduct of the state. Both costs was occasioned by the conduct of the state. And that is why I would differ from your leadership with respect.
Yes.
I just continue quickly insofar as the judgment of Mrs. Justice Phillips. It is true that Mrs. Justice Phillips, if you read the judgment, would have liked to have applied the de facto officer principle. But at the end of the day, my lord, she concluded that it was inapplicable. And reluctantly, she had to follow her brothers, who held that it was also inapplicable. Mr. Justice Morrison says initially he was attracted to it, but later he was persuaded that it did not apply. And it couldn't apply because the judges' positions, they were filled by new judges.
Well, we don't need to go there, do we?
You do not.
Because that's not up for grabs on this appeal.
I agree, my lord. So that is the question that...
I appreciate it was raised in submissions.
I understand, my lord.
But I really don't think we need to go there.
So the question was raised, and my lady mentioned it as to whether or not my learned friend says we would know whether an application was made to the Governor General, and I have responded to that. I assure you, my lady, if one was made and it was refused, it will be front and center in the judgment. It's not our fault. My lord, if there are nothing else, those are the points I would reply to.
No, I have one question, Mr. Braham. I want to be clear in my mind, it's precisely the order you're seeking. I think you're simply asking us to allow the appeal and therefore to send to the Court of Appeal the question of, or one or both of, depending on how well you do, the third-party costs order or the constitutional redress? Or are you asking us to decide one or other of those questions ourselves?
I believe that your lordship is in a position to decide the questions yourself.
Both of them, or just the wasted cost, the third-party cost question?
About one moment, crave your indulgence.
That is what he needs to do.
Your lordship, of course, would not be asked to assess the costs.
No.
Right. But I can't, with respect to my friend, see why your lordship cannot say to the Court of Appeal, you had jurisdiction and you ought to have awarded the costs. And similarly, that on the question of costs generally, that this was an appropriate case, that costs could have been and should have been ordered.
That's in relation to costs. And, and if you don't succeed on costs, what about in relation to constitutional redress?
I say...
We're not asking.
We are asking for relief, for redress. We are saying that we should be compensated by way of costs. And I am saying if your lordship should agree, then your lordship can direct the Court of Appeal, advise that that would have been an appropriate thing to have done.
So you're asking us, are you, to make an order for redress on the basis that it's equivalent to the costs and the costs to be assessed in the usual
by the
way?
taxing master.
Yes, I see. Thank you. That's very
I crave your indulgence, though, to consult with my friend.
Thank you.
That would be all.
Thank you very much, Mr. Brand. And the board is grateful to all counsel and to those who have assisted them in their making of their written and oral submissions. And the board will take time to consider what advice we to tender to Her Majesty.